This is Horum with Horum's Quorum. My guest today is Pratik Shah. Pratik is the head of the Supreme Court and appellate practice at Akin. Pratik has about as pedigree a resume as you can get, but I'm struck with the down-to-earth conversation here about the perhaps unlikely path he took to get here as a first-generation lawyer. And there's plenty of places you can learn about advocacy as an appellate lawyer. We certainly cover some of that, but this is a rare opportunity to explore the market and the business of appellate litigation. Here's Pratik. So I'm excited to have you here, Pratik. Your lens on practice is fascinating, and you have a pretty unique story for someone who came from maybe an unlikely place to end up where you are now. And so we'll be interested to get into that part of your roots in Akron later on. But I want to begin with you have a really unusual story that I think you've told in some smaller venues, and I'll be excited to share it here, about some surprising impact of some early conversations you had in law school, and how that led you down a path that had a big impact in your career later.
Yeah, I'd start in my first year of law school. I was at Berkeley, and like many first-year law students, trying to figure out what I was going to do for that summer afterwards. And I stumbled into one of those summer luncheon sessions, and this one was about judicial externships. And there was a panel of clerks who were currently clerks in California courts, and I needed to establish California residency at Berkeley, so I knew I would stay there. And one of the panelists was someone named Vince Chabria, now known as Judge Chabria, on the Northern District of California. And he was then clerking for Judge Breyer on the Northern District of California, and talked about the opportunities to be an extern for the summer. And I ended up, submitting my resume, and Judge Chabria was kind enough to share it with Judge Breyer, and I was able to, have that opportunity for that summer. And that summer, maybe more than any other experience or job I've had in the law, may have had the biggest impact on me. For a variety of reasons. One is because Judge Chabria and Judge Corley, who was Jackie Corley, was also the other clerk for Judge Breyer that year. So all three of them are now somewhat fortuitously on the Northern District bench as judges. But they went out of their way to be great mentors and help a first year law student along. And Judge Breyer what was a fantastic boss. I mean, most people wouldn't be taking interest in unpaid, first year law students who are externing. But I recall vividly, that one day, I came into chambers. I had been assigned to do some sort of memo in a bankruptcy case on a due process issue, which sometimes arises in bankruptcy cases. And I think I was somewhat nervous about it because I hadn't taken constitutional law yet at Berkeley. That's taught in the second year. And so I'd written this memo and submitted it to the judge. And the judge said, "Why don't you come up to chambers to discuss the memo?" And I came up to chambers, his office, and he said, "Well, Pratik, I haven't yet had a chance to read this memo closely yet, but my brother has, and he has some questions." And then he kind of gestures off to the side, and I turn my head, and much to my shock, I see Justice Breyer sitting on the sofa there with a copy of my memo in his hand. And that may have been the last clear memory I have of that morning. If I had blacked out, I don't know. But no, it was, we had a round table discussion. I remember, the justice sitting there, the judge sitting there, Judge Chabria and Judge Corley kind of smirking, there. And it was obviously a very memorable experience for me. And I share that story, I guess, for a couple reasons. One, obviously it had a profound impact on me to have that opportunity as a student, and believe that, okay, look, I can be in these circles, and think bigger, and about future opportunities. But also, I think it said a lot about um, the people in that room: Judge Corley, Judge Chabria, Judge Breyer, and Justice Breyer, all of whom made that possible. Right? They did not have to do that at all to give that opportunity to a first year law student who hadn't taken constitutional law. What benefit are they getting out of talking to me about it? But I think it speaks to their willingness to be mentors, to be educators, and obviously had a big formative experience in my life. I have no reason to think the justice ever remembered that encounter. Obviously, I went on to clerk for him a few years later. But maybe I got the confidence to apply, and obviously I'm sure some help behind the scenes from Judge Chabria and Judge Breyer along the way.
What was the impact after that? Did that, like, after you got over the initial shock, I could easily see someone might, like, the ego meter might go through the roof. We all met people like that in law school after just like their first semester, they did well, and oh wow, now they're just like, like swaggering down the halls. Did that happen to you? And if not, why didn't it?
Yeah, I guess you'd have to ask the people around me to see if that was true. Hopefully that didn't happen to me. No, I think I just remember being mostly thankful for having that opportunity. I think it's something that has been a big part, and I think my career has been the role of mentors, and it wasn't just that experience in isolation. It was Judge Chabria taking an interest and saying, hey, look, I know your background. I know how you did. Here are some judges you need to apply to for clerkships, right? Like most, I don't think any law student has a great idea of how the clerkship process works, but especially law students coming from families without any lawyers, probably like a lot of South Asians, at least of my generation. That made a big difference, right? And that gave me the confidence, hopefully not overconfidence, but at least the confidence to apply to clerkships. I went to clerk with Judge Fletcher on the Ninth Circuit after that, which was just a wonderful, wonderful experience, because he is just one of the best human beings on the planet. Forget judges. And then later on to Justice Breyer. So I think it had an impact in that way.
Let's start with Judge Fletcher. What's one or two practice points, maybe something very practical or bigger picture with career and how to think about it, maybe either directly or indirectly? Because I can think, I externed for 2 federal judges in law school, and there's things that they directed to the other externs that was helpful, but it's also things that they just incidentally said to us as well that they didn't even necessarily know the impact it had on us. So I'm just opening the spectrum of kinds of things you could have learned. What's one or two things that takeaways from that experience have stayed with you?
Yeah, so I'll give you one very concrete practical tip, lawyering tip that I still remember. It was on the very first project that I had there that has stayed with me, and that I share with other young lawyers. And then one kind of bigger picture thing that I think is more impactful. But the very concrete lawyering tip, since you asked of concrete things, is it was a statutory case, I remember. And, those of us, I think I'm old, but I'm not so old such that we didn't have Westlaw and stuff when I was in law school. So a lot of us kind of do legal research, especially as young lawyers, using Westlaw or whatever, and even looking up like statutes, right, online. And you read the provision, and you go about it. And in that, I remember in that case, you read the provision and you think it means one thing. And I remember Judge Fletcher telling me, this analysis makes a lot of sense and all of that. But here, if you pull the book, and he comes in with the book, and, he flips through the surrounding provisions, right? it kind of puts it in a context that maybe, look, there's another way to read this. And so when I do, when I have statutory cases or whatever, I actually, try to get the volume of the statute. And I look at books probably more than most of the younger lawyers, but I think in that specific context, there is actually value to having surrounding context that you can't just get just through quick online research, but it's much easier to flip through a book and do that. So, there was that sort of concrete tip that I still use in practice now. But more broadly with Judge Fletcher, it's, he just shows you, no matter how brilliant someone is or how accomplished, he's an Article III appellate judge on the Ninth Circuit and all of that. Just there isn't a more down to earth person that you'll meet. And so you ask that question about ego, right? And when you have models like that in an early on, that you see someone who's so so prominent and accomplished, but yet you would never know it if you saw him on the street, right? The one rule in chambers we had was you can't dress better than the judge. And that was a hard bar to meet, to be honest, with Judge Fletcher. He just did not have any airs about him. Ate lunch with us every day, and talked with us, just as you would talk to anyone else, or maybe how he would talk to his kids or otherwise. And so, that has certainly stuck with me.
And so you had this early connection with Justice Breyer. And so, of course, it was obviously you could apply to the Supreme Court and to clerk with him. Heading into it, though, what did you think you were going to get out of a Supreme Court clerkship? I mean, it's an obvious, of course, it's just what an incredible, credential to get, an experience to have, what a unique experience to have. And so there's obvious things about that, but specific to you, what made you say, I want to do that? And what's the payoff going to be for you?
Yeah. So at the time I was thinking maybe academia. I really like law school, and they tell people, look, if you really like law school, maybe you'd really like being a law professor. And the other thing I was thinking is, maybe becoming an appellate advocate, having clerked on the Ninth Circuit. That was the area of law I was exposed to, and I really enjoyed it. And so for those paths in particular, a Supreme Court clerkship becomes very helpful, just because that is a credential that whether it's in academia, law schools value, or if you're going into appellate practice, is valued. And so for me, it made a lot of sense based on those were kind of a couple of the paths that I was thinking about. Beyond the fact, obviously, it's just an incredible experience. Even if you wanted to do nothing related to that, even if you didn't even want to practice law, the Supreme Court clerkship, is just a special year, right? You're 2 years removed from being a law student, and then you're kind of sharing chambers and talking about legal issues with, the best legal minds in the country, and the justices who've are just legal giants, right? And so, and because of the weird way in which the Supreme Court works, right? I mean, it's a pretty isolated existence for the justices, even probably more so back then than today, where, their interaction is really, with their four clerks, and maybe some informal interaction with the other justices, but not a whole lot in kind of formulating their views. And so you have this unusual interaction where you have, people who are really going to be making important decisions for the country, and then discussing them with folks who are 2 years out of law school. So to have that vantage point and be able to start grappling with some of the, kind of biggest legal issues of the day at that point in the career is kind of, is just an experience that you can't really replicate. And so that, I think that's a reason for anyone to want to do it, regardless.
What do you think is the single most misunderstood aspect of the Supreme Court?
Yeah, it's a good question. What I'll say is that, and this is, something that, I think different people may have different views. I don't think it's as true as today. It was a different court, when I clerked on it. That was the 2003 term. So you can see how old I am, over 20 years ago, now. And I guess what I'll say about that court is, it was a court of relationships. Obviously you still had a lot of 5-4 decisions right there. At that time, it was Justice O'Connor who was the swing vote. But, think about that time, right? Justice Scalia and Justice Ginsburg, polar opposites, right? But their relationship is well chronicled. And for those who clerked at the court, that's not just made up, right? It is a true relationship. The fact that Justice Breyer would go and talk to Justice Kennedy, right? He not always would he be able to influence him, but sometimes he would, right? They would have a real dialogue. Even Justice Breyer and Justice Scalia, right? You're talking about, folks who had opposite schools of constitutional interpretation. And yet, they went on a roadshow for the country to see, hey, look, here is how we have two different views, but here's the common ground. Here's how we're different. And you could just tell that the relationships mattered. Justice Thomas, has said publicly, like, he looks back fondly on that court, because he felt they really trusted each other. And, in some ways, I think, I had the privilege of clerking for Justice Breyer, who, I think kind of in a lot of ways embodied that court. He's not someone who's interested in debater points, right? He's not, he's not interested in zingers. He puts a premium on relationships. He often talked about how 9 people with different views managed to be so collegial. They would have these weekly conferences where they decided cases, and sometimes they didn't go your way. But no matter how it came out, he would come back, and he would continue to be optimistic, right? That the process is working, right? We had the dialogue, and maybe we didn't get this one, but the next time around, maybe we'll be able to persuade a majority. It speaks to his personal fundamental decency, I think fair-mindedness and optimistic outlook. I think qualities that I've tried to, bring, into the practice, that I do, but I think it's qualities that I think all of us could mirror more today. And I think a lot of the divisiveness you see, in court opinions today, in writings about the court, in things like that is a big change, from, back when I clerked.
What is it that most, maybe now, not necessarily, maybe then or now with the benefit of other experiences, what surprised you the most about Justice Breyer?
Yeah, I mean, I don't think there's anyone, who I can think of that truly, genuinely believes to his core in our system of government. And, that really embodies kind of his entire jurisprudence, his being. And I'm not just talking about the judicial process, right? That judges are just trying to come to the right answer. And, people have different perspectives, and it's not all result oriented, right? People, I think, I'm not just talking about that, right? People have their own views on that, although I do believe he really believes in the process, and each of the justices and judges are really giving their best good faith effort to get to what they think is the right answer. He certainly believes that, but more broadly, he believes in our system of government, right? That everything should be designed to kind of strengthen the democratic processes so that people can participate in government, get their views heard. He talks a lot about law bubbling up, and it's really something to the core. And I think in today's world, even back then, but certainly now today, where everyone is jaded and everyone has, believes that government's dysfunctional, that little good comes out of it, that, judges are just, you hear the critique that they're just politicians in robes, all of that. That is something to his fiber that he doesn't believe. And so, to be with someone who, right? I mean, he's not someone who hasn't been exposed to everything, right? He was on the Senate Judiciary Committee, as chief counsel, so he's been in the legislative branches, learned from Senator Kennedy. He's been at the highest levels of the judiciary, and still he believes that today. And so, that's, I guess, something surprising, but also admirable.
And what have you found what's a perspective that you have that differs from him, a disagreement you have? Like, where does your worldview depart from his?
Yeah, I mean, it's a good question. I think it's hard for us to have that same level of optimism and faith in the system. Um, when we're confronted with today's world. And so, I guess to me, it's become more complicated in trying to have that same faith. But I try to keep some of that same optimism.
Nice. Okay. And then tell me about your path from the Supreme Court to the Solicitor General's office.
Yeah, so I taught constitutional law for a year. I was thinking about that. I then ended up at Wilmer Hill in Boston for a couple years, and after maybe 2 years there is when I applied for an opening at the Solicitor General's office. And if I had to pick, right now we've touched on perhaps the two most formative experiences early on. The third one has to be my tenure at the SG's office. I think for any young appellate lawyer, it's hard to imagine a better job to learn how to be an appellate lawyer. So much like in the Supreme Court clerkship, I was talking about you're 2 years removed from law school and you're there. Well, in the Solicitor General's office, you might be 2 years removed from a Supreme Court clerkship, and you show up at the Solicitor General's office. I had only argued one other case in any court, and that was an intermediate court of appeals, state court of appeals in Maryland. And then you come to the SG's office and your next argument is going to be in front of the Supreme Court. But you're not thrown in there completely blind, because you get the privilege and the opportunity to learn from really the best, in my opinion, the best Supreme Court advocates in the country. The deputies, the Solicitor Generals are obviously always very esteemed appellate practitioners. I was the last hire of Paul Clement, which I think speaks to the truly bipartisan nature and institution of the SG's office. But there are career deputies, right? When I was there, Ed Needler is still there. Michael Dreeben was there, the criminal deputy. Both of them have well over 100 Supreme Court arguments each. And when you watch them at work, I mean, just their substantive knowledge, the way they go about it, you're really not going to get a better education in how to be a Supreme Court advocate. And so for me, that was, a transformational time from being an aspiring appellate lawyer to actually, becoming one and doing it. And so, yeah, it's a special place.
And we've there's actually, because we've talked before, I know there's actually somebody might see your resume and see this kind of like march of progress and miss out on some of the behind the scenes actions that happen to get there. So I actually think let's double back to that 1L externship, because I think that's where the story starts of how you started making connections and then how you started learning that skill set of networking, which was, I think, new to you, so many people, but particularly as somebody as a first gen law student. Tell me about, how that journey started, and I want to pick that up as you progress in your career.
Yeah. No, I am not a natural networker. I think those who know me well would know that. I don't think it's something I've ever really shared with a group of people, but I'll say it now. But
By definition, if you're not a good networker, I'm just
right.
You're not telling other people about this stuff. So.
Yeah. So it was so kind of foreign to me that I remember at the beginning of law school, when you have those receptions or career workshops when firms or other people came, I would actually, because I wasn't comfortable approaching people and talking, I would literally write down beforehand to myself on a little scrap of paper, kind of like 3 bullet points of things that I thought people might find interesting, or things to talk about in that context, just to make me more comfortable and not be on the spot. And so, I think I've gotten past that at least, but there are little things along the way, right? Like you said, go back to that first year, Judge Chabria, I do feel like I owe him a lot because he did take that interest in me, and not only with facilitating that interaction with Judge Breyer and Justice Breyer, but helping me with the clerkships, right? When I clerked for Judge Fletcher and then later for Justice Breyer. And then, it didn't end there, right? Along the way, right? I mentioned the SG's office. We talked about becoming there. Actually, I remember now, someone had put me in touch with now Chief Judge Sri Srinivasan, who was just an assistant in the Solicitor General's office at the time, when the opening had come open, and he was leaving the SG's office. And so, someone set up a phone call, and I had a phone call with him about the job, and then I applied for that opening and got the job there. And then when I joined the office, there was another assistant still there who was a few years ahead of me, Canon Shanmugam, who's one of the country's best Supreme Court advocates. And so I got to know him there, and lo and behold, as he leaves, in comes Neil Katyal as the principal deputy, and got to form a strong relationship with Neil. And then when Neil leaves, who comes back? Chief Judge Sri Srinivasan becomes the principal deputy. Neil was the principal deputy under Justice Kagan, who was then Solicitor General, and then Sri became the Chief Judge Srinivasan became the principal deputy under Don Varelli, and so got to come full circle from that very initial conversation I had with him to actually working with him and forming these relationships. Those folks happen to be brown, happen to be Indian, which, I think honestly, it made me more comfortable, to form that relationship, right? And to with them. It doesn't obviously mean your mentors have to be, of someone of your same ethnicity by any means. But for me, at least, someone, again, might not naturally form those relationships. It made it easier to have that common ground. So I think there is something to the fact of having folks come. I think it does make a difference. It forms a path. I've tried to do the same for those coming after me. I think it's a little interesting niche of the bar. Obviously South Asians are growing in the law, but the Supreme Court bar is one where we've been long established now as a strong community. All the people that I mentioned, Chief Judge Srinivasan before he became a judge, Neil Katyal, Canon, myself, Deepak Gupta, Preeta Bansal before all of them. And now many after me, right? Aisha Anand, who argued like 3 cases last term. Tajinder Singh, there's Vivek Suri and Sopan Joshi in the SG's office right now. Tons of folks. And so here you have this little corner, and I don't think it's coincidental, a little corner of practice where, through the SG's office, there's been a chain and a network, if you will, of folks who've been able to support each other, at least in some way, or another.
Then, building on that, can you speak to how the process of professional growth and mentorship at the SG office? I mean, of course, when you're a Supreme Court clerk, that's a term, there's a term that you're a clerk for, and it's terminal in that way. But can you compare the experiences of training, mentorship, and et cetera for the SG's office as a training ground versus the Supreme Court?
Yeah. So, clerkships, I think are great grounds because you don't have to have any networking or any ability to do anything. It is natural mentorship, right? I think many judges view that as a critical part of their role. And so that's why I highly recommend clerkships, even if you have no interest in appellate law, even if you have no interest in litigation, do a clerkship, because that is the easiest way to form this relationship with someone who knows a lot more than you, has been accomplished, and will really become a backer for you, for years and years to come in your career. And that just happens organically through the process. And so that's a really nice natural thing about clerkships, whether that's a district court clerkship, a court of appeals clerkship, or a Supreme Court clerkship, right? I don't think that is a differentiator. I think that is something that happens with that. In the SG's office, it's obviously not structured in that way, right? This is your job. You're a fully formed lawyer. You're going out and practicing, but it's a small office. And I think that makes it very comfortable to kind of form these relationships and learn, right? I mean, the office, I think, for those who aren't familiar, is shockingly small. 16 assistants, 4 deputies, and the SG, you're talking about 20 attorneys. That's it. That do Supreme Court litigation for the entire United States executive branch and oversee all of the appellate litigation in the courts of appeals for the federal government. And so when you're in that small environment, I just think it's easier to thrive, to learn from others, to form relationships, have conversations after an argument. Hey, you were awesome. Here's one thing you could have maybe, here's one way to handle that question differently, or you could have done this, right? Those are conversations that happen in the SG's office after every argument. Everyone's very supportive, but at the same time, you're kind of learning from each other as well.
Are there any advantages you can think of to training in appellate advocacy at a firm as opposed to government, for instance, SG's office?
Yeah, look, they both have great value, right? And at different points in your career, one might make more sense than the other. I mean, the advantage of the firm is for very young lawyers coming out, and this is what I did, right, early on at Wilmer, right? You had the opportunity to work on, I had the opportunity to work on the Boumediene case in front of the Supreme Court and be one of the primary drafters of that brief, along with happened to be one of my co-clerks at the Supreme Court, Julian Mortensen. We got to do that with Seth Waxman. So you get these great opportunities to learn from great folks and be involved early on. I think the difference is in the government, when you go out, you can get oral argument opportunities. They're more plentiful, and they just kind of you don't have to worry about paying clients, authorizing a very junior person to do significant oral arguments. At the government, that's just how it's done, right? And so there's opportunities there. That's something, quite frankly, in our practice, as I've, come over to the private sector and where I've been, that realizing that we put a big premium on trying to get oral argument opportunities for our associates, because I've always found that to be the one lagging part of big firm appellate practice. And I've tried to take the lessons from government and realize, look, if you want to be an appellate lawyer, it's important to get oral argument opportunities. And so that's something we try to put a big premium on, is getting at least one oral argument for each of our associates every year. And then naturally it happens and they build more over time on their own, but it takes some work to do that in the early years. So that's, I think, one of the differences between government and private practice.
Yeah. And going back to the SG's office, in one of our earlier conversations, I asked you, hey, what was an inflection point in your career? So you talked about the Defense of Marriage Act, and its course at the Solicitor General's office. So can you talk a little about that?
Yeah. So the Defense of Marriage Act arose while I was an assistant in the SG's office. And up until that point, in the Bush administration, and quite frankly, in the Clinton administration before, the federal government had always defended the constitutionality of the Defense of Marriage Act. And just to remind everyone, the Defense of Marriage Act was the federal law that said the federal government would not recognize any same-sex marriage, even if it was lawful under state law. So for purposes of Social Security benefits or any million other federal benefits, there was a federal law that said the federal government would not recognize same-sex marriages. Like I said, it was defended during the Clinton administration, defended during the Bush II administration. And then when President Obama came into office, he and Attorney General Holder made the decision that they would no longer defend the law because they believed it was unconstitutional. And so the Justice Department put a new team, including in the Solicitor General's office, to reflect that change in position. And I was part of that Solicitor General office team, along with Chief Judge Sri Srinivasan, who was then the principal deputy. And so we worked on that case together for the federal government. In briefing, I wrote the brief challenging the constitutionality of the Defense of Marriage Act in the Windsor case, which went on with Robbie Kaplan arguing for Edith Windsor and Don Verrilli arguing for the United States. Went on, and the Supreme Court struck down, as everyone now knows, the Defense of Marriage Act is unconstitutional. And then that formed the basis for the decision a few years later in Obergefell that recognized marriage equality as a constitutional right. So, that was a formative experience for me for a lot of the reasons, some of the obvious, right? It was a landmark case. But also, it was the first time I was part of a case where there were so many interested people, not just in the public at large, but even within the government, right? People had been defending this law for a long time. It wasn't an easy decision. It's not something the government often does, is attack its own federal law. So there was that, dealing with that constituency. There were a lot of people who felt strongly. On the other hand, the meetings on the law were, filled with people from different agencies. Watching how Don Verrilli navigated all those dynamics was a true learning experience, working closely with Chief Judge Srinivasan and developing our arguments along the way, working with Robbie Kaplan, the great Robbie Kaplan, along the way. And then personally, obviously it's not, at least of that generation in the South Asian community, not something that was easily discussed, but, I've had since I was very young an uncle who is gay and has lived with his same-sex partner ever since I was a little boy. And my grandparents came to accept that. I'm sure I was too little to know, the struggles to get there. But we remained very close, and I know it was incredibly meaningful for him and our family, when they got married shortly after those decisions in the state of Washington. And so, professionally, personally, all of those things, a meaningful case for me.
Mm-hmm. And then I guess, I think part of what we talked about before was the significance of that case for you was really, coming into your own as an advocate and as a professional to kind of, understand your potential and understand what it felt like to be steering your own career, to be a leader. Can you talk a little more about that legacy for you?
Yeah, I wasn't steering the ship in that case by any means, right? That was Don, that was Shri. I was the one writing the briefs and developing arguments, but that did lead. You're right. It was formative in the sense that was towards the end of my tenure in the SG's office. And that's honestly what led me to start thinking about, what's next. I'd been there, over 5 years at the time by that point. And it felt like, gosh, it's going to be hard to top this experience working on that case. I loved the job. I loved briefing, arguing Supreme Court cases. I've already talked about what a great institution the SG's office is. But the one piece that's missing from that is you aren't the one steering the ship, right? You're not the one ultimately making what's going to be the the government's position in the case, and what are going to be the major strategy calls. That's ultimately not your call as an assistant. That's the SG's call. And so as I was thinking about it at that point in my career is, hey, look, am I ready to try to take that next step and kind of be the one who's making those strategy decisions, making the ultimate calls, taking more of a leadership position, in my cases and in the practice. And that's one thing that, you're limited in your ability to do that in the SG's offices, as an assistant is greater places to be. And so I think that's what probably got me thinking, hey, what's the next step?
And so the next step for you was a return to private practice. Tell me how you assessed the landscape and how you made a decision about what was the properties of the firm you're looking for, and what were the right conditions for you for success?
Yeah. So when I left, which is now over a decade ago, when I left the SG's office, as I kind of viewed the landscape of appellate practices in DC, it struck me that there were kind of like three different models or types of practices. One was kind of the large mega practice where I had been an associate, for example, at WilmerHale under Seth Waxman, or Carter Phillips at Sidley, or the late Ted Olson at Gibson, Dunn and Crutcher, right? Big built out practices with a former solicitor general or other very prominent person with maybe a half dozen partner deputies or more, and then senior associates, mid-level associates, junior associates built out, right? So that was one model. Probably not the right model for me because I was trying to go somewhere where I could be in the leadership capacity driving the bus, and you're not going to do that when there's Seth Waxman, Carter Phillips, Ted Olson already at those practices. The opposite end of that model, the second model I'll say, is the kind of free agent model, or really a firm that's interested, doesn't have an appellate practice, but wants to bring on an experienced Supreme Court litigator to either to have it or to build one. So if you think about some of the New York firms that didn't historically have those, there have been a number of people who've gone on and done that very successfully. Cannon did it at Williams and Connolly originally, Jeff Wall now at Sullivan and Cromwell, Doug Hallward-Driemeier at Ropes. We were assistants together. And they've all been incredibly successful. And the upside there is, you build it in your vision. But there is, I'm not going to talk about the stories that it did not work out, because that's a big risk at those places that haven't had it. And also you don't have that group, right? You might be able to do the practice, you're the person, but you're working within a general litigation group, and you don't have that same tightly knit kind of well-defined group that you might have in a clerkship or in the SG's office or in one of those bigger firms that I had mentioned before. So I think there's some pros and cons to each of these, but that's how I saw it. And then there is what I, view as the third, what for me, the Goldilocks model, which is, look, a well-defined appellate group, but it's small. It's not led by a former SG. It's small, it's strong. But there's room to build, there's room to grow, but it's got a foundation and it's got established appellate credentials. I think a number of folks who I would put in that category. Akin obviously is where I am now. I would put in there Jenner, Morrison and Forrester, all places like that with super high quality appellate practices and people that I think fall in between those two other extremes that I mentioned. And for me, that seemed really appealing, right? You have a real group of appellate lawyers that you can be part of a small community within these big mega firms. And yet it's not so big such that you need a hierarchy that you might at some of the bigger firms. You can really work with everyone. It can be very collegial, very horizontal rather than vertical. and you can shape its direction, you can grow it. And so at the time I was coming out, President Obama had just nominated now Judge Millett, but Patty Millett to the DC Circuit. And so Akin was looking, and she was head of Akin's Supreme Court and appellate practice at the time. And I believe she had reached out to Judge Srinivasan, who was then the principal deputy solicitor general, and he put us in touch. I did not know Judge Millett at the time, but he put us in touch, and I ended up hitting it off with Judge Millett in terms of kind of, I think, how we viewed, we had both come from the Solicitor General's office. She had spent even a longer time there before my time. I think we had just a very, very similar vision of, she had hired a group of folks who were very down to earth, super smart, talented, Supreme Court clerks and all the like, but also folks who are very down to earth, and which is how she is, for any of you who know her, and just hit it off and felt very comfortable, felt like I could trust her. And that's where I ended up going to try to build and take the reins from her and build on all the wonderful things she had done, and A, not screw it up, and B, hopefully build and grow it over the years.
So you mentioned a few other peer firms that are kind of in that same bucket of that Goldilocks spot. You mentioned, I think I heard you say Morrison, Forrester, Jenner, and I'm assuming there's maybe a few others. How would you differentiate Akin's practice from those peers?
Yeah, look, no, they're all great practices and great folks at them, close friends and others from the SG's office, all folks who I admire. And that's one of the cool things about the appellate community is, we all, a lot of us have filtered through the SG's office at one time or another. We do moot courts for each other as favors and all of that. So there's a lot of synergies. What I can say about Akin is, I think, we've really tried to build the culture, really putting a premium on people who really like working together, right? There's no doubt about it that we're a big law firm and everyone works very hard and all of that stuff. And so if you're going to be somewhere working hard, let's do it with people who you really want to be around. So it's a non-negotiable. We're going to hire, right, the most talented folks. And we've been very lucky because we are relatively small. We hire maybe one person a year that we're able to kind of, get, the pick of the very best talent in the country. But that's not enough, right? Is it someone who is going to fit in with our culture? And be someone you really want to interact with. There's very little management I have to do, to be honest, of our group, because the people are just so, work together so well. And so that's, I think kind of been a defining feature. I guess that the other thing I'll point out is the fact that we all argue cases, from top to bottom. We had our associate, Margo Risconi just argued her first ever case, not just a pro bono case, but for a paid client in kind of a bet the company type matter in the Fifth Circuit, and won, right? And because we are relatively small, our matters tend to be more leanly staffed. And so the clients get to know not just me or one of the other appellate partners, but get to know the associates on the case too, because there might be only 2 or 3 of us on the case. And so that gives them the confidence, because it's often hard to talk a, paying client with a big thing to say, hey, I'm going to trust someone to do their first argument in it. But if they've seen that person at work and interacted with them and really learned that they're the brains behind the operation, then, I think that happens. And so we try to do that, whether it's through a pro bono opportunity for the first few arguments, or like for Margo, a paid opportunity. One of our other great, talented, wonderful counsels, who came to us from Justice Sotomayor, is going to be arguing in the Second Circuit next week, for a major case for Kodak, like a big case for Kodak. And so, these are the sort of arguments that our associates are doing. And so, yeah, it's just been a real privilege for me. the one last differentiating factor I'll mention is in my time here, we have not hired a single lateral partner in my decade at Akin, all homegrown. We've made 4 homegrown partners. I was the only one after Patty left here in DC. We've made 4 homegrown partners in my decade or so here, and that's just our philosophy. We're going to hire the very best people we can, and hopefully they'll want to stay. Not all do, right? We've had people who go into academia, want to go into the government, have all sorts of different interests, and we support them there. But for the folks who want to stay and make this their home, I think we've been able to do that. And, that's not me. It's coming from a lot of support from the firm. There are probably not a whole lot of firms for a practice of, less than a dozen people that would make, 4 homegrown partners in a decade. So, that's not leverage that a big firm normally would have, but I think they recognize kind of the value of and the talent of the people that we're able to bring in.
And then help me understand, let's paint a historical picture here, then to get some sense of trajectory into where we are today and where we're heading. So help us understand what would the market for appellate litigation look like 10 years earlier, before you joined. So you joined 2013. What would it look like in 2003? What would it look like in 2013? And what does it look like today? Like what are the differences at those 3 points?
Yeah. So I would say, a decade or 2 earlier before I joined, there wasn't a big market in the private sector. And, quite frankly, that's why in earlier times, I think people stayed in the SG's office a lot longer, right? There were a lot of assistants, at least at the time that I joined or shortly before I joined, that had been there decade plus, in the SG's office. And I think part of that is there wasn't a private sector option really for you to do that same sort of practice in the private bar. A lot of Supreme Court cases decades ago were argued by the trial lawyer or by, the state government person, or there wasn't that large specialized bar, certainly not in the private sector. Folks like Carter Phillips and Andy Pincus and those guys on the vanguard, Seth Waxman, Carter Phillips, they started these, practices in some of the DC firms. And I think slowly but surely, I think firms caught on that, hey, wait a minute, this seems to be a high value proposition, maybe not just in the bottom line of dollars and cents, but these are bringing on really talented lawyers that handle high profile cases that can add a lot of value to the firm, both tangibly and intangibly. And so those grew over time, right? All the ones that we talked about, and then the new ones coming up. So as I said, so if you go back, 30 years ago, just didn't exist, right? And then, by the time I'm coming out, 10 plus years ago, they're pretty well formed. And you have those different models that I mentioned. Now, fast forward now, I've noticed the turnover in the SG's office, 3 years. People leave, right? 2-3 years. That was unheard of, right? That was viewed as, no, you shouldn't be coming for that short of a stint. I was almost 6 years and few people, some stayed a little shorter, a little longer, but that was, within the realm. And now I think people are leaving because there are even more sorts of variations on those models, right? There's those models and other things in between. And so the demand is increased in there. I think there was always a concern. I even remember when people said I was coming out, they're like, geez, the market looks pretty saturated, right? For Supreme Court appellate advocates, and, not sure, what the opportunities really are. And yet year after year, people come out, find great jobs, succeed. And it is interesting because during this entire time, over the decades that I've been talking about, the number of Supreme Court arguments has shrunk, right? 30 years ago, before mandatory jurisdiction, there were, 150 cases, being argued. Back when I clerked, 85 cases, now this past term, under 60, right? So it's a smaller set. So it's not, outside of, maybe, Paul Clement or someone, there aren't a lot of people arguing half dozen cases a term anymore. But what's happened is that it's really become a developed practice in the courts of appeals, federal courts of appeals. Now, in virtually any high stakes appellate dispute, I'm seeing one of my counterparts from the Supreme Court bar on the other side, in circuit courts across the country. And so the Supreme Court bar, the primary practice for all of us is in the federal courts of appeals. And then, and that's become, an area where, again, I think in high stakes cases, more often than not, you'll see, folks with that background doing it, which firms have recognized, which clients have recognized, and then the other reason why I think the demand continues to increase is regulatory litigation, right? Not even appeals at all, but they look a lot like appeals. There's no discovery. And that area has really just exploded, honestly, with all the changes, both in terms of how the agencies have been acting, but also the changes in the Supreme Court jurisprudence, right? No Chevron, major questions doctrine coming along. The judiciary much more skeptical of federal agency action. So clients challenging agencies' rules, regulations in whole hosts of areas, healthcare, trade, environment, securities, labor, all of that. Now, if you look at it, it's almost always someone like me or one of my counterparts that's involved in those litigations, even though they often start in the district court. They work just like appeals, oral arguments, and then they work themselves up the chain fairly quickly. So the practice is diversified. I've seen even in my 10 years doing it, I did virtually none of that in my first 5 years at Akin. And now we do a whole lot of it. And so I think that's all been part of the evolution.
So let me make sure I understand the evolution right. So part of it is substantive, that there's, a new frontier of disputes around regulatory disputes. And part of it is there was an existing amount of, let's say, appellate work. There's less Supreme Court matters to argue, but there's I haven't seen any numbers on appellate activity. Has appellate activity changed much, say, in the past decade or so, of matters that go to the appellate courts?
Yeah, I don't know the statistics on that. What I bet, though, at least anecdotally, what I would say is that clients have become more sophisticated about hiring for high stakes disputes folks from appellate practices like ours, rather than just sticking with your trial counsel. I think that was probably, and obviously that still happens today, but that was probably how it happened, much more often in prior times, right? You stick with whoever, win or lose, you stick with them, especially if you won. But nowadays, especially the more sophisticated clients, and especially in high stakes disputes, as I said, I'm seeing more and more of my counterparts on the other side or the same side of those types of cases. So I think that's been a related development.
I think it's interesting to note that in so much of the story you're describing here is one of mobility. So you're talking to the SG's office and how tenure is, dramatically shorter than before. So that's a story of mobility. And then there's also a story of client mobility of, hey, let me send this matter to sophisticated help counsel. That's interesting. That's just an interesting story to know that, you see this in the legal market as a whole. You see there's a lot of mobility among associates, among counsels, among partners, just in every aspect of legal practice and private practice. You're seeing just greater mobility of lawyers and then of matters, it looks like.
Yeah, I think that's right. I think that's right. There's no doubt about it. I mean, you know better than me, but yeah, you see big name partners leaving firms, changing firms, true in the associate ranks as well, and yeah, with matters as well, right? I mean, and it's also with the increasing specialization, right? That's not unique to appellate law. That's in the law in general, but I think appellate practitioners have benefited from that in that, I think clients want to go to the experts in that and for appeals. And even it gets even more segmented, right? Patent appeal specialists or people who do administrative law appeals and all and that. So I think that has also been a contributing factor, increasing specialization for sure. The one other area I would mention probably why firms have found it valuable, and you've seen this increase is, and again, this is not a dollar cents thing, but in pro bono cases, right? There, I think firms do find value in being part of it, both as a part of the professional duty of being a lawyer, but also in terms of those are often cases that get a lot of attention and bring attention to the firm and positive attention to the firm. I mean, we've historically, and we're not unique among appellate practices, although I think I do think we tend to emphasize it a whole lot here at Akin. But we've always litigated kind of big pro bono cases over the year, whether it's in the and depending on the firm's bent and maybe the leadership's bent, that might look differently, what you define as your pro bono cause. But for us, it's been civil rights, immigration rights, LGBTQ rights. I had the privilege just 2 days ago to second chair an argument, which I haven't done in a while, but at the Supreme Court at least, second chair an argument for Chase Strangio, the trailblazing ACLU lawyer, who's the first openly transgender lawyer to argue in our challenge to the Tennessee's ban on gender affirming care for adolescents, which was honestly, which was just an incredible experience for me, just being able to work with Chase closely and play that supportive role for a younger lawyer. And he's truly a trailblazing lawyer. He's been litigating these cases around the country, but to work closely with him, and he did an incredible job. And our Solicitor General Elizabeth Perloger did an incredible job arguing that case. But from a firm standpoint, it's just to be somewhere where that. I feel really lucky to be an Supreme Court appellate lawyer, and our practice, I think, feels really lucky because that's a part. It's not like we do that in addition to our job, right? I mean, often the hours, if you look at our matter hours, some of the heaviest matter hours are Supreme Court cases that we've taken up along the way might in any given year be a pro bono, non-billable case in that sense. But that's just part of we don't differentiate. That's just part of the practice. And it's, and I think it's one of the best parts of being an appellate lawyer.
Well, you hear this from lawyers all the time, is that there is, there are firms have policies around pro bono hours and credits, et cetera, but at least tacitly and sometimes counter to those rules, there's overt communications about, hey, just limit how much pro bono you're doing, and this is too much. So it sounds like your practice is really unique in so clearly being expected to contribute in that way, but a firm is still a business. And so then how do you communicate and get buy-in from the firm to confirm that, hey, I'm confirming this is still valuable to the practice group, that, we are still getting compensated for this in every sense. Like, how do you it's such a unique position that you're in to ask for substantiation of something that is not revenue generating. So how do you do that?
Yeah. I think the firm sees the value in it. We've been doing it for a long time, and they keep making partners in our group and keep treating us well. So, I think they see the value, but, I don't want to take it for granted. You're right? Not all firms make that calculus, right? That's why you don't see marquee appellate practices at every firm, right? Or even firms that have them, you don't see the level of pro bono. I think stuff that we do, or some of our peers, do, because I do think that, I think we have a leadership, that is extremely supportive, that truly believes in it. The chair of our firm is on the board of the, LDF. I think there is, I think there is that. It's going to depend firm to firm, but And so I think if you're thinking about which firm to go to as a lawyer, that's something to think about, the track record and all of that, because it isn't a given, that's going to be viewed as a high value proposition. Now, of course, we're adding value in all the other ways that I said, right? The high stakes disputes in the Court of Appeals, those are not pro bono cases by any means. When you're getting hired to do, those cases by the NFL or SpaceX or whoever it is, McDonald's, whoever our clients are, those are important cases for those, firms, important, for those clients, important for our firm. We're able to do stuff that strengthens the other. You may say, okay, well, our practice might not be the most profitable, but what we do strengthens the most profitable practices, at the firm, right? I argued the Purdue bankruptcy case, the opioid bankruptcy case for the victims of the opioid crisis, right? That is a representation that our bankruptcy group, one of the largest in the country, had been doing for years and years. In the trade practice, we have the largest trade practice in the country at Akin. We in the appellate group are leading the challenge on the China tariffs in the largest Section 3, in the largest trade litigation in the history of the Court of International Trade, right? So we're able to add value to the marquee business, profit generating practices, that I think that the firm, can see in that way, even if we, at the end of the day aren't ourselves generating it matter after matter.
And then can you speak to origination of work? Because you talked about, it says at least one matter was a product of matters referred from other practice groups. Tell me about the landscape of, are there practices that are destination practices for appellate matters? Because you talked about part of this concept of now more than ever you're seeing that trial counsel isn't necessarily becoming appellate counsel. So it sounds like there's becoming a market for appellate counsel for certain kinds of matters. You also know that certain courts are especially, require more expertise, like the Federal Circuit has got, its own jurisprudence and quirks. And it's beneficial to have a substantive knowledge of, say, patent law. So how do you see, how appellate practices, how do they approach business development, just broadly speaking? I guess that's the big picture question, and this question of originating work is part of that.
Yeah. So, I think appellate is unique in that sense, in that, I view it as there's two bases to business development. There's internal and external, right? A significant part of what we're doing, I would say at least half, is still internally generated, right? Matters that folks in our various other practice areas at the trial level are handling, right? Whether that's IP, like you mentioned, or trade or labor or Indian law. We do a lot with our Indian law practice, those sorts of things. So we form very close relationships with some of those strongest practice groups within Akin that generate high value work at the trial level, trial court level. And so that's an important part, is forming relationships within your firm with the people and groups that have the sort of work that is going to generate and justify hiring, a high-end appellate shop to do it, or that will even be pursued on appeal, whether that's to the Court of Appeals or Supreme Court. That is an absolute important critical part of, I think, success of any big firm appellate practice, is forming those relationships. And it works, I'm sure, differently within each firm. Like I said, I had the blessing of coming after Judge Millett here, who had formed a lot of great relationships and credibility within the firm for us. And, I think we've been able to build off of that and expand those relationships. That is a huge part of it. And then the other part is the external part, right? There are, over time, you develop clients, even if they don't use Akin for some of those other practices, when they have a high stakes dispute or an appellate dispute, or quite frankly, regulatory litigation, right? I mentioned that originates in the district court. So they may just come to us. A lot of industry associations, right? We have relationships with the Chamber of Commerce, and others might come to us directly to handle those. And then, of course, there's the occasional pitches you get invited to, and based on referrals and all of that. So that's part of it, like any other practice. But yeah, the big difference is I think at least I view it as I have this, this internal and external, a business development, if you will, that's necessary to really have a successful appellate practice.
And what do you do personally for external business development activities?
Yeah, I did different now than when I first started, right? When I first started, I had never been a partner at a firm, let alone leading a practice or anything like that. Judge Millett was hugely helpful in that and flying around with me to meet all clients. I just remember the first 6 months being a blur because I was always meeting clients and, giving talks and doing that. And quite frankly, in the government, no one knows who you are, right? And nobody publicizes anything you do when you're, at least back then before there are all the blogs prominent, people just don't know who you are. So a lot of it is just getting out there, getting people to know you. Now I've been doing this 10 years. And so that part of it becomes easier, right? You don't have to be out there promoting and meeting with clients and all of that. People start to come to you, which makes that easier. But still, I'm doing a lot of talks about especially in the end of the term, beginning of the term, that summer season, right? Where the Supreme Court is in recess, DC Circuit is in recess. The nice thing about appellate practice is it does typically dip down in busyness over the summer, which is great. You have families and all of that stuff. There's still briefing and all that stuff going down, but argument prep time goes down. And I replaced that with doing talks on the Supreme Court on appellate advocacy. I really enjoy that. It also happens to have the benefit of getting you in front of lots of groups, clients, whatever it might be, bar associations, law schools, whatever, that exposes you, and things happen in mysterious ways, right? You would never guess some ways in which work ends up coming back to you. And so yeah, I think that's all part of the process.
What part do you enjoy the most?
Oh, yeah. Probably, doing the talks on Supreme Court. It's an area of, for basically my entire career, right? I've been watching the court and doing it. It's still something I find fascinating, and I really love what I do. Don't tell the firm this, but I would do this probably for a lot less. And so, it's something I really naturally enjoy. I'll be, for the first time actually since I taught con law after my Supreme Court clerkship, I'm going to be teaching a class this spring at Georgetown Law School on constitutional litigation and the executive branch with Joshua Matz. And so it's something I really just enjoy.
Is that a lot of work to prepare an outline for constitutional law now?
Yeah, we'll see. We'll see. It starts in the spring semester. I mean, it's not going to be a true first year con law class. It's going to be a seminar that talks about case specific examples of constitutional litigation against the executive branch. And I will certainly be incorporating some of my own cases, which hopefully will help in reducing prep time and still making it more interesting for the students, since I can share some actual firsthand experience.
How has the experience of teaching impacted your career? What is it compared to someone who hasn't taught the way that you have? How is your practice different than somebody who wouldn't have had that experience?
Yeah, I mean, probably not a lot. I mean, honestly, there are some, I'm not going to say it categorically. There are a few academics who make good appellate practitioners. I think Toby Heighton's a great example, right? We were in the SG's office together. He was a professor at UVA, came over to the SG's office. He was a phenomenal advocate, appellate advocate, now on the Fourth Circuit. But sometimes academics don't make the best appellate advocates because they're thinking big thoughts, concepts, trying to harmonize things, where when you're in an appellate court, you're trying to win a case. Or when you're in Supreme Court, you're trying to, reconcile precedent history, the things that the court is interested in, not necessarily your academic theory. And so I'm not sure that, teaching has a big impact on how I, having taught. And again, it's been now, almost 20 years since I last taught. So I can't say that, but we'll find out. Maybe it'll make me a better or worse practitioner after reteaching this spring. So we'll see.
So speaking of education, I want to go back to your early experiences because there was an inflection point that happened for you even before you went to college for your education. So can you take us back to your roots a little bit about those early influences and the trajectory that sent you on? Because I think in many ways, learning about the earliest years helps us understand that your outcome was, it seems like less predetermined and subject to some early luck and some benefits you received then.
Yeah, and I'm happy to start talk a bit about that. I grew up, as you I think mentioned in the beginning, in Akron, Ohio. That's where I was born and raised. Like many of folks in our generation who grew up with parents who immigrated from South Asia, my parents from India. I grew up in a working class neighborhood in Akron, stayed in the same house all the way until after I left for college. There, and not great schools in our area. I was the only Indian kid in my elementary and middle school. I had a great experience, I will say. There are challenges along the way, but my brother, who was 5 years older, I think had the foresight. He went to the high school in our area, which really wasn't doing well. And I'm thankful for his foresight. And he told my parents, you can't send Pratik there. And so I ended up going to a Catholic high school in Akron, even though I'm not Catholic. Never been to a church, and then I'm raised Hindu and Jain. But for the education, I ended up going there. And I do think that had a big influence on kind of where I ended up after that. It was a great academic experience there. I ended up applying to Princeton and going to Princeton for college. A large part of that was the fact that my Masi lived in Sayreville, New Jersey. And so that, it gave everyone comfort that we had someone close by. But I did end up going to Princeton from there. And, in a lot of ways, having grown up in Akron, where I was the only Indian kid in my elementary, middle school. But, we had a small Indian community on the side of maybe, I don't know, 10 dozen Gujarati families who lived in Akron, who kind of spent the weekends with growing up. I'm still in touch with some of the kids who I grew up with back then on those weekends. It's kind of a second world, almost. Princeton felt a little bit like that to me. In not just in the South Asian, non-South Asian sense, but just in the cultural sense, and that, felt a little bit like I was entering a new world there. Obviously, there were a lot of kids like me from small towns or, more disadvantaged backgrounds or whatever. But there were also a lot of kids from boarding schools and elite schools and all of that. And so, it was an adjustment there. But like anywhere, you find your community, you find your people. There was also a small South Asian community of friends at Princeton. I'm sure it's much larger now, but back then a small group. You find the other folks there. And I did chemical engineering there, and it was a great place to do that. It was a small department, which I found very helpful, just given my personality, and allowed me to grow and think about other things. A lot of people who do engineering there don't go on to be engineers, and I was kind of in that boat. I did engineering, but didn't want to be an engineer, and it wasn't the most certainly the most educated decision. But after that is when I ended up in law school. So it was an unlikely, I guess, trajectory in some ways. But if I had to pinpoint, my big brother back then, saying, hey, let's send him to Hoban, open up some opportunities, made it to Princeton, opened up more opportunities, right? It's not a story unique to me by any means, all made possible by the parents taking the true true leap and coming to this country and allowing those other much smaller leaps or steps to happen. So my story is not by any means unique. I know a lot of people who probably listen to your podcast can relate to it in a bit, but yeah, that's a little bit about how I got to where I ended up.
And look, I mean, you went to Princeton, and there's many people who came from very privileged backgrounds at that school in particular. Part of your story is that you happened to make a relationship with one Judge Breyer who knew another Judge Breyer. So what are the odds these two siblings both had, the position they had in society? So there's pools of people that had these kinds of outsized performance, and we can spend a lot of time talking about whether that's nature or nurture or whatever. But the point is that there's some groups of people that do have some advantages of terms of relationships and networks, et cetera. And something that you were talking about early on is that, hey, you were not natural at this and you had to kind of figure this from scratch. And you get this like 1.0 version of 3 bullet points you wrote down to have these conversations with. So I guess I'm curious, as a big picture question is, compared to some of those pedigreed peers, the peers who did have the ties to lawyers and did have some insights into, hey, here's how you choose a law school, and here's how you think about feeder judges and all these other kinds of insider information, that among comparably talented peers is a differentiator in terms of outcomes. What were the advantages of not having those advantages?
Yeah, I mean, I guess one thing you have when you don't have all of that kind of background coming in is you are coming in as a blank slate in a lot of ways, and so you don't have preconceived notions. Like, I had no idea when I ended up at Berkeley, law school, what I would eventually be doing. I didn't know that appellate law was a field. I didn't know what the Solicitor General's office was. I didn't know about clerkships. I just didn't know that. And so I didn't have any preconceived notions. Whereas I guess if I had come in with, a lot of people who knew about things, and maybe, I know I wanted to be some corporate securities litigator, and I wouldn't have considered anything else. And I would have gone down that path and done the things that there, and not kind of stumbled into this path that put me on a trajectory to become a Supreme Court appellate advocate. And so I think there are advantages, right? You do that, but it is, and I'm sure it's true in every field, right? But law is the one that I know. It's an opaque process, like clerkships. Like, how do you go about even deciding who to apply to? How do you make that happen? And it seems, I know they come up with these plans and all of that, but it can start pretty early on, or your grades from the first year. But I think when we were in law school, I'm trying to remember, I think you applied just after your first year, so you only had a year of grades. Like, how do you figure out how to do that? And so, finding it is, I think, a hugely important thing. And we had at Berkeley, like all law schools, right? We had our affinity groups, which were strong. Then it was in the aftermath of when they had ended affirmative action. So the affinity groups were particular emphasis on those groups, and that played a role with me, as I mentioned, meeting Judge Chabria and having his input and other students there. I think it is super important. Now we have, I think, many more formalized ways in which to do that. There's the Appellate Project, a great organization that, matches up first generation law students of color with more senior members of the bar. I'm sure law schools have more formal programs and all of that, but I do think it's an important thing to help shed light on what can otherwise be a pretty opaque process.
Mm-hmm. So, speaking of opaque processes, I think a lot of people don't understand. We were talking about how the Supreme Court makes their decisions and some of the behind the scenes about how ideas are socialized and how they end up drafting their opinions. And so as a clerk, you have unique perspective on the court. And I recognize, as you say, the court has changed and changed in terms of how they work together and work on their opinions. But it'd be hard to miss this opportunity to ask you about advocacy and your principles for advocacy. So let's start with there's briefing, there's oral advocacy. Let's start with briefing. Tell me about, at the highest level, what are the three bullet points, if you will, for your principles for appellate briefing?
Yeah. So, I mean, I think the overarching thing about briefing is, right, you want to build a narrative so that the court wants to rule for you. And here we're talking about Supreme Court briefing. And so almost never do they have to rule for you. They're the Supreme Court. They can change the precedent. They can kind of do anything they want, as broadly, as narrowly as you want. So if we're talking about Supreme Court, you really need to come up with a narrative that makes them want to rule for you. Now, how that's done is going to depend a lot on the case, right? You know that but there are a finite set of tools that you're working with. In some cases, it may be that precedent's on your side. In other cases, it may be that text's on your side. In other cases, maybe neither of those on your side, but you've got policy and common sense and equities on your side. So, right, depending on what sort of case it is and which of the tools are going to be strongest for you, to me, it's shaping that narrative around whatever tool is going to be most effective for you to get the court to want to rule for you. And so that's, I guess, at the highest level, that's kind of how I think about it at the outset of a case. At the Supreme Court is maybe different from briefing before the lower courts.
And then in terms of, you've got this raw matter of the trial court record. And so maybe we can expand this conversation to appellate briefing as well as Supreme Court briefing. You've got this raw matter. How do you shape that to go to the appellate level? Like what is a high level principle you're using for, I am prioritizing arguments, and what else am I prioritizing? And, at a really high level, how do you sit down? Like, what is your order of tasks you approach with understanding the subject matter you're working with and how you're going to present it?
Sure. So I think key, what I think most appellate lawyers will tell you, and certainly I'm a believer in this, is that, right, and again, this is not true for all cases, but generally speaking, look, you're looking for legal issues, right? Issues of law, right? A lot happens in trial. And I think this is really the value out of being appellate lawyers, is sometimes it's easy to get stuck into the facts and the morass of what happened. And wait, this was found wrongly against me or my client, or, that's not how it actually happened and all of that. I think cutting through that to get to legal issues, appellate judges are much more comfortable when it comes to deciding pure issues of law. So trying to figure out, okay, here's everything that happened. What is the best legal issue that I can present? And I can weave in the equities and the facts and all of that, but let me distill this to 2. And I don't want 10. I don't want 8. I want, give me 1, 2, max 3. Right. In terms of questions presented in an appeal, so that the judges can really focus on, distilling what might have been months and thousands of pages, if not tens of thousands of pages of record, into a 50-page brief.
And then, when you think about, how to prioritize arguments, are there any principles you're using there for, let's say there's 3 arguments, what is a further principle you might use for organizing?
Yeah, a lot of that's going to depend on the case, but, at the highest level, and this is not rocket science, always start with your strongest argument, right? That's what, even if it might not logically always be in that way, but, judges have limited time. These appellate courts are busy. They get a lot of cases on any given day. They might be hearing 4 or 5 arguments. Let's come out with what is our strongest argument and let's make it. And even in that, like I said, I want 1, 2, or 3 max issues in an appeal. And then that gets even funneled further by the time of argument, right? I want to be trumpeting my best argument. Now, maybe there are times to pivot if a judge happens to be The reason why you brief the others is maybe one judge is interested in one of the other arguments. Great, you do that. But usually by the time through that briefing process, through the opening brief, and then by the reply brief, if you have a reply, you can funnel it. You get a better sense of funneling it. And then by argument, the idea is to have it really distilled to what is your best argument.
And do you have a formula for how you prepare for oral argument?
Yeah, that's changed over the years. In the early years, in the SG's office, in particular, and you're getting ready for argument. I used to, for example, one of the things I used to do is I used to write out questions, and I would, in fact, do Q&As, and I still do that to some extent, perhaps less than I did then, but you would write out all your Q&As. And, but the thing that was different back then is I would actually, put those questions, write out those questions on, pieces of paper, or note cards or whatever. And I would give them to my wife, who is not a lawyer. She's a pediatric oncologist, has little patience for legal discussions and even less patience for me. And so I would give them to her. And this was, in the pre-kid era, before we had kids. And she would, I would say, hey, can you ask me these questions? And she would ask, randomly pick out one of the cards, ask me the question. And without fail, after about 20 seconds of me talking, she'd be like, I'm bored, move on. And so it would force me really to crystallize my answers into succinct nuggets. Now I'm going to sound really old, but I'll say back in the old days of those Supreme Court arguments, before the changes in post-pandemic changes where they changed the format of arguments, that was truly, that was the challenge, was because the questions were relentless. There's still a lot of questions in Supreme Court arguments if you listen to them, but they were really relentless in that pre-pandemic days before you had this protected round of questioning at the end. And so you really needed to be able to succinctly answer things and then pivot on to something else, because you really just didn't have that ground. So again, I'm sounding like an old man. Back when Supreme Court arguments were really hard and challenging, they're still hard and challenging, but that was a particular skill. And so that was something I used to do, is have her answer questions. And then now, once we had kids and, all of that stuff, that all fell by the wayside, and I fell into my preparation, doing a lot of the same things. Obviously, look, I'm going to reread the briefs closely. I'm going to come up with my few key Q&As. All of that I still do. The most important part of preparation, though, which is true then, true now, I'm a strong believer, and this is the Solicitor General's office model, is moot courts. That's now become ubiquitous, I think, in the appellate bar. But it really started in the SG's office, and did 2 moot courts for every case in the SG's office. I still do that now, today, for any case that I'm arguing here in private practice. And we do that for all our cases. We do 2 moot courts. Whoever's arguing doesn't matter. And we have people asking questions who have not worked on the case previously. They pick up the briefs, they read them just like the judges would, and you do, whatever it is, an hour of Q&A, and then debrief to do it better. There's no better practice I've found for preparing for argument than that.
Well, on the topic of, what you trained at and learned at SG's office, so you've trained with people like Seth Waxman, you trained with people like Sri Srinivasan. How does your style differ from some of these key influences?
Yeah, there are different styles, obviously, of Supreme Court argument. You got to be true to your, what you're comfortable with and your personality. I mean, Paul Clement, who hired me, who's kind of, one of the best Supreme Court advocates of his generation. I think Justice Kagan described, there are, I think the words she used are heaters and chillers, right? Like he tends to amp up in an argument, right? Amp up the energy, amp up that very lively argument style. And then, on the other side of the coin, there are people who tend to be very tempered, very measured in the way that they're arguing cases. I think of Leandra Kruger. We were assistants in the Solicitor General's office together. She's now a justice on the California Supreme Court. But, you go listen to one of her arguments, very soft-spoken, brilliant arguments, but just bringing the temperature down and calm, cool, and collected, no matter what how pointed or how aggressive the questioning might be. So I've learned from watching all of those folks. Some things you can imitate, some things you can, and some things you have to be true to your style. I guess others would probably be better suited to describe where I fall in that spectrum. I will say, though, that sometimes you have to adjust, for the type of case that you're that you're arguing. I mean, the example that comes to my mind, which is, I think, out of my normal style, out of my comfort zone, was the Purdue opioid case that I argued last term, where, I was arguing on the same side. And I think there's different variables you have to keep in mind when you're an advocate, but I was arguing on the same side with Greg Garr, who was representing Purdue. And, Greg, by personality, Greg is a phenomenal advocate. He was one of the 5 solicitor generals who I served under, and just an awesome person, very low key. That is Greg, right? Measured, methodical, and quite frankly, representing Purdue, probably and fit appropriately with the demeanor there, answering questions in a low key, methodical way, sticking to the law. I was arguing with him on behalf of all the opioid victims and all of that. And so I knew that my role was really to channel the victim's voice. And so I think, as Justice Kagan said during that argument, "Wow, Mr. Shah, you're being very emphatic." And so I think, she recognized that it was not my normal style, but I think it's what it was the right thing to do for the clients there, and the right message to send for the court to get across the equities and the importance of the case there. So I think, there are going to be different styles. Great advocates have different styles. So there is no one style. You have to see what fits your personality, what you're comfortable with, and go with that.
Maybe this is a dumb question. Justice Kagan knows your style. What do you think is the actual impact of you varying how you spoke about the case? Okay, you chose the emphatic style, which makes sense. It matches that demographic that you're serving, and just so too, it just the corresponding Purdue is chastened by all its impact it's had. There's no dispute about the negative impact that opioids have had, and the only question is what to do about it. And so it makes sense that you chose that style. But what do you think actually was the impact of choosing a different style at that moment?
Yeah, well, I don't know. You'd have to ask the justices. We still came up a vote short. But I think it allowed us to communicate. Everyone would have to listen to the argument to do, but I think it did create space for us to communicate some very important points that were reflected, unfortunately for us, in the dissent, but came through, and I think impacted the questioning that the justices did. You never know. Obviously, it's hard to know how it would have turned out otherwise. I think it was the right call in that moment. But yeah, you've got to, kind of do what makes sense to you, and hope that resonates with the justices.
Well, maybe, and again, with the repeated caveat that I recognize the court has changed over time in composition and how it operates. But at the time that you clerked, what was the practical impact? Help us understand what really happens at oral argument and the practical impact it has on shaping judges' decisions.
Yeah, I think, different judges will say, I think, different things. I think what you typically hear, which is what I think I tend to agree with, which is, and this may differ a little bit between the Supreme Court and the lower courts, whereas I think oral argument generally makes a bigger difference in the courts of appeals than it does the Supreme Court. And you can kind of probably see why, right? In the Supreme Court, these are justices which have very well-formed views. Now, I think there are a subset of cases in which oral argument can make a difference and does make a difference, and certainly makes a difference in a much bigger number of cases how the opinion is written. But as to the ultimate result, I think briefing ends up being much more important than oral argument, generally speaking, in the outcome of cases. I think oral argument you can lose a case at oral argument pretty easily by making bad concessions and making mistakes. I think it's less common for you to be winning cases at oral arguments, but it does happen. And so obviously you want to be as well prepared and positioned you can to maximize the odds of that happening.
And with that in mind, your approach to oral argument then is playing defense to make sure you're not giving up anything?
Oh, no, not at all. I think that's just something that I think you don't want to do, right? I mean, I don't think you prepare not to give away the case. I think I've seen it happen a fair bit. But I think that's just comes with the territory and advocate. No, you are trying to frame the case in the best possible light for your client, for your position. That's what oral argument to me is about. And of course, addressing the hardest questions and the biggest vulnerability in your case, because judges will ask about that. And so you have to take that head on. I think that's the biggest your biggest role in oral argument.
Look, I mean, from what you describe about appellate practice, it seems like even with all the changes you described, increased mobility, and then increased competition, all things considered, appellate practice still seems very glamorous. So what are the reasons why a skilled litigator, maybe somebody who clerked the Supreme Court, let's say, what are reasons why someone might pursue a trial court practice rather than appellate practice?
Yeah, it's a better question for the trial court litigators who you interview. What I've heard over the years is some will say, oh well, appellate litigation is like playing tennis without the net. Right. Right. I mean, you don't have that challenge of, all the stuff that goes on in a trial court and the back and forth and the, cross-examination and all those kind of, I guess, my cousin Vinny moments or whatever. To me, at least from my perception and understanding of trial practice, what I appreciate is not having to deal with all the hassle that litigators often have to deal with, real litigators who do trial court litigation have to deal with in terms of, discovery disputes or nasty grams between lawyers over all sorts of things. That is by and large absent from appellate practice. Usually the only things you're fighting over, like briefing extensions, which usually everyone agrees to, or, things like there just isn't that much to fight over other than the substance of the case. And so, now that the one change for me, as I mentioned last few years doing regulatory litigation in the district courts, I've now encountered that more. And that's reaffirmed my belief that I chose the correct path in being an appellate lawyer, because I don't enjoy those, fights over procedural things and timing and preliminary injunctions and all of those things that seem much less orderly and don't really go to the substance of the legal issues in the case. The other, benefit, I guess, in the appellate bar is because it tends to be a lot of repeat players, especially in the Supreme Court bar in particular. But as I mentioned, often see them in the courts of appeals. You have that personal relationship. And so that also, I think, makes it much easier in communicating and a lot less of the games and, missives and all of those things that I think are more common in other types of litigation.
Okay, so still basically only reasons to be an appellate lawyer. Okay, got it. So that's the best job there is out there. I got it. Okay. So for all the associates who are listening to this, or maybe law school students or even earlier who are considering a path to appellate litigation, How do you even think about guiding someone about that? So we already know someone's driven. They've got all the intellectual prerequisites and dispositions to enjoying the kinds of subject matter that happens in appellate litigation. Maybe we've already covered the why to pursue it. Maybe more tangibly how to pursue it.
Yeah, I mean, appellate, is a field in which there is, in many ways, kind of an established track, right? And so it's not, it is a pretty known, it's a path that you can follow and embark on if that's something you want to do. Clerkships are the starting point, right? And in particular, clerking for some sort of appellate court is I think an important step in that process. And so I always emphasized anyone who's interested in becoming an appellate lawyer to really think hard about clerkships and doing a clerkship and taking from there. Now there have been circumstances, but they're unusual. We'll hire someone in the appellate group. I mentioned Margot Rusconi earlier, one of our associates who argued in the Fifth Circuit, and she came to us from Georgetown, directly having not even clerked yet. And, she had done night school at Georgetown and gotten some bad advice that, oh no, night students aren't going to be able to get good clerkships or whatever. But then she took a class with Judge Millett, who was teaching there. And, I think Judge Millett told me she's the best writer she's ever had it in any of her classes. And so, we brought her on. She was fantastic. And then when she was here, she applied for clerkships and got A+ clerkships, Judge Kelly and Judge Cuthledge on the Sixth Circuit, and then came back here. So there are ways to get around it, but the typical path, you do your clerkship and then, you think about joining, one of those appellate, obviously Supreme Court clerkship would be great. And then, joining one of those appellate practices. But there are other opportunities as well, either at the outset of your career or once you've done this for a few years. Department of Justice, outside of the Solicitor General's office, has, stellar appellate components in the civil division, the criminal division, environmental division. Various components within Justice Department have their own appellate sections. They have an honors program. They take young lawyers, and you get to start arguing cases very early on in the federal courts of appeals. There's state solicitor general's offices now. That's another new development. Didn't exist when I was coming out of law school, but they have now developed much in the mode of the solicitor general's office. The states having very sophisticated and high quality solicitor general's offices. That's opened up a whole number of opportunities for young lawyers in appellate. In the appellate space. So I think in some ways there are more opportunities than there used to be.
What do you attribute that rise? Why is the states have elected to start this, and why didn't they have them before?
Yeah, same development, right? Increased specialization, realizing the value of having these, and now you'll see a whole bunch of states with former Supreme Court clerks and others as their state solicitor generals, often pretty young lawyers as well, which is opening opportunities for younger lawyers to take leadership opportunities in that avenue. And that's red and blue states, right? You've seen that phenomenon in both, and that's been part of the trajectory, right? And this increase in the Trump administration, blue states taking the lead and challenging Trump policies, in the Biden administration, red states taking the lead. Those suits, by and large, are being led by these state solicitor generals' offices, who have now become, pretty high power type appellate shops.
Well, so it sounds like you make all these joking references to how old you are and how to how ancient your experience is. But something I'm struck with is I think probably Justice Breyer did have an impact on you with your optimism, that you really are someone who any number of people would be tempted to describe changes as for the worse, but I haven't heard you describe overall the trajectory of the appellate bar as anything for the words. There's challenges and there's things maybe that you disagree with, but overall, just it creates more and more opportunities for litigators to develop their craft and develop business. So I think I'm struck with that optimism that you have. And I'm glad we sat down to talk.
Yeah, it's been a lot of fun. Thank you, Coram.